Greetings, dear colleagues, dear candidates, and the public. Today, on January 21 of 2025, the advisory group of experts has gathered to conduct an interview with candidate for the position of the judge of the Constitutional Court of Ukraine, Oleksandr Tkachenko. All members of the AGE are present at the interview: Mr. Aleš Zalar, Mr. Yaroslav Romaniuk, Mr. Vasil Shakun, member of the AGE, Madam Hanna Sukhotska, Secretary of the AGE, Madam Marina O'Connor, and I, Chair of the AGE, Oksana Vasilchenko. Also, we have deputy members of the AGE present at the interview: Mr. Volodymyr Kuzmenko, Mr. Richard Barrett, Mr. Marek Zubik. I would like to point out that we work in shelter, so in case of an air raid alarm, the interview will continue without interruption. I would also like to remind you that the interview is being recorded and broadcast live at official resources of the AGE and of the Constitutional Court of Ukraine. I'm also drawing attention of the AGE members and of the candidate regarding restriction of the use of sensitive data and information with limited access live. If necessary to discuss such issues, the AGE will suspend the broadcast. So we are ready to start. I'm passing the floor to the AGE Secretary, Madam Marina O'Connor, for brief introduction of the candidate and reminder of the interview rules. Madam Marine, please, the floor is yours.
Thank you. Good afternoon, everyone, dear colleagues, the public who is watching this broadcast. As our Madam Chair has already said, the advisory group of experts conducts an interview that we interview the candidate for the position of judge on the Constitutional Court of Ukraine. It is the choice of the candidate to interview. It is mandatory that we offer that choice. One interview is, now our interview has begun, and the interview will last no more than 1 hour, and the time limit for answering questions is no more than 3 minutes. Traditionally, we ask all candidates to be concise, to answer clearly, unambiguously, and stick to the essence of the question that is being asked. At the end of the interview, the candidate will be able to make a short closing statement that will be no more than 5 minutes. So I would also like to note that during the processing of materials about candidate Tkachenko, the AGE sent him questions to provide written explanations, so the candidate has had the opportunity to prepare for this interview and also to provide answers. So now we have with us a candidate for the position of Judge of the Constitutional Court of Ukraine who was admitted to the competitive selection by the Competition Commission under the President of Ukraine. Mr. Tkachenko is a retired judge of the Commercial Court of the Mykolaiv region. In addition, I'd like to remind you that this candidate has participated in competitive selections last year and has been interviewed by the advisory group of experts previously. Mr. Tkachenko, you want to add anything to your presentation about your credentials that you deem to be relevant? If you would like to do so, you have no more than 3 minutes.
Microphone, please. No additions, thank you.
Thank you.
Шановні колеги,
Dear colleagues, then let's start. Oleksandr, as Madam Marine has mentioned, you already participated in the competition for the position of the judge of the Constitutional Court of Ukraine with respect to persons appointed by the Congress of Judges of Ukraine. I would like to remind you that these were two competitions announced on September 18 of 2023 and April 15 of 2024. The AGE, during previous competitions, took decisions dated March 23 and November 7 of 2024, you know about the text of these decisions, and you also know about those issues and those circumstances that were thoroughly studied by the advisory group of experts last time. So, do you confirm all the answers you have previously provided within the framework of previous competitions? Yes, I do. Yes, I do. Oleksandr, would you like to provide any additional information and supplement your written or oral answers? Microphone. All the additions that I wanted to provide have been provided by me in writing in response to questions of the AGE. Thank you. Madam Hanna, please, your turn.
Yes, I have following the question. I have the question. What is your motivation for participating in the competition for the third time in circumstances where you do not provide any information that would refute the conclusions of the advisory group of experts regarding your not compliance with the criterion of high moral qualities for the purposes of selecting candidates for the position of judge of the Constitutional Court? What is the reason for the third time you are studying?
The reasons are the following. With those grounds under which I was recognized as non-compliant, I agree with one ground that I did not recuse myself during consideration of case in 2009, but since then over 15 years have passed. That's firstly. And secondly, I participate in the competition to the High Council of Justice as well. And according to the law on the HCJ, which is also the constitutional body, just like the CCU. The law sets out that bringing of a person to administrative responsibility for corruption offenses is not a ground for non-appointment of the person as the member of the HCJ if a year has passed since the moment of being brought to responsibility. So even if I had been brought to responsibility for corruption offense in 2009, that is adoption of the decision in the conflict of interest, 14 years have passed since then. And this is not a ground for my non-appointment to the HCJ. And I believe that the similar logic applies to the Constitutional Court. And I disagree with the rest of grounds. Should I explain with respect to each ground separately? I disagree that, firstly, with respect to incorrect specification of information in the declaration regarding boats. I believe that I correctly interpreted the current legislation of Ukraine, just like the NACP interprets the law. And the AGE is mistaken in the interpretation of the law as to how boats should be declared. With respect to my failure to fulfill the court decision, I do not even know what else, which other arguments I should provide, when it is obvious for any reasonable ordinary person that I will come back to the Criminal Code of Spain, which sets out that a person may not be brought to responsibility for failure to perform the court decision if this decision is obviously illegal. And not only for a judge or of the Supreme Court or the local court, it is obvious for any reasonable person that the decision 5507, which I failed to fulfill, is unlawful because the decision contains no evidence, which is a separate standalone ground to declare it as illegal. And secondly, it is based on false evidence when the legal entity, with the help of the court, recognized the right for the document, for the agreement that was concluded 6 years before establishment of this legal entity. For people to be clear, if, for example, one person is demanding property from another person, and this person is claiming that this property was bought 6 years before its birth. I do not know. I do not believe that this decision is enforceable. And even if the decision were justified, I should not perform it, because according to Article 28(1), the decision under vindictive cases should be performed not by the debtor but by the enforcement service. And instead of performing the decision, and I did not prevent the bailiff service from doing that. I told them they can do that. They penalized me for failing to perform this court decision, and then the proceeding with the court has been going for 3 years, and they cannot study the documents of this legal entity, whether this legal entity owns this garage or not. Well, basically that's it. That's everything that I wanted to add, if I have not forgotten anything. Well, with respect to my non-declaring of the fact of me being brought for my fines, Article 62 of the Law on the Judiciary stipulates the following. In the declaration, the judge should point out actions which might be a ground for bringing this judge to responsibility. If the Supreme Court says that these decisions are performed by the bailiff service, then my failure to fulfill this enforcement letter is not a ground for me bringing to responsibility. The Ukrainian legislation does not contain such grounds that the debtor should fulfill this enforcement letter instead of the bailiff service. And contrary to requirements of the procedural code, the enforcement letter does not adhere to the resolution part of the court decision, and as such this enforcement letter is a subject matter of a crime set out by Article 366, that is, inclusion of inaccurate, incomplete data into the official document. So, while taking the decision, while issuing the enforcement letter, the judge put there only one part of the resolution part. So, that was incomplete information in the enforcement letter, which is a ground for bringing the judge to criminal responsibility even. That's it, seemingly.
Alexander Vasilievich, if we understood correctly, then the decision of the court we are talking about now, about the enforcement of which has become active, is now to enforce. Your experience allows you to defend, to protect your rights. You have mechanisms to prove that fact of the illegitimacy of the decision, or that enforcement letter is not in line with the law you mentioned now. Which actions have you undertaken to prove that facts which are now pronounced during this interview with you for your opposition to the court? After the first decision was taken, all these three cases are connected to that dispute about the garage. I tried 3 times by changing the subject matter and the grounds of that claim, on that the court is not legitimately acting. Then when the representative understood, he submitted not credible documents, he brought other documents to the court with which he was proving that that garage about which it goes, he is passed not 6 years before that, but before the creation of that entity, but later then. But the court hasn't studied that. When seeing this, I submitted to the court to review due to the newly disclosed circumstances, but the court hasn't reacted to refuse this my new evidence and to confirm that the debtor, AGK Parma, itself doesn't recognize that that garage was retrieved from me according to the demand they applied to the court. So it goes about a different time of demand for that garage. I want to add that another two cases are now in the Supreme Court connected to the situation. The first case, I have got a decision where I haven't seen the proofs, the evidence, the grounds based upon which I was deprived of the ownership title. Obviously, I have addressed to all these three instances to ask what are the grounds, what are the real and grounds according to which that garage was overtaken by AG. All the they say that the decision is clear and understandable, maybe for them, not for me. Okay, if it is clear and understandable and the Supreme Court recognized those decisions are well grounded with relevant evidence, but the decision on that reference has no evidence, no true and real evidence, I applied to the Supreme Court on the relevant precedent. I applied to renew the materials of to update or to review the materials of the case. Maybe that proof was lost. That is why this case is still under consideration of the Supreme Court. Another case is in the Supreme Court about me claiming against the legitimacy of that enforcement letter. Now it is in the appeal stage, and the judge who took decision based upon the faked documents, and 1 year after that, after he understood or she understood he was there was a misbelief and he recognized the documents have been faked. Anyway, he recognizes the actions of enforcement body were legitimate. So it is a contradiction. What else have I to do? I have addressed to the ombudsman, and he says that if the judges do behave in such a way, I have go to the High Council of Justice. I addressed to High Council of Justice. Few of my complaints are there. I even submitted an application there on the violation of the authority of justice, of judiciary. It was violated because the attorney, the lawyer, knowing that this document was violated, he referred to the document of 1993. It doesn't matter. He knew that the legal entity was created only 6 years after 93, and the court satisfied that motion. So such actions, when the court acts based upon fake documents, is violating the judicial right. But the other chambers believe that is not a violation of the judicial rights. Thank you. We understand your position, colleagues. Put your questions to the candidate. If there are no questions, the candidate can state the conclusion. You asked me about what I already said. I wanted to state in this 5 minutes, so I will be brief. In my motivation list, there are two statements. One statement is the discrimination of the local judges, of the local courts compared with the higher instance courts should be removed, should be eliminated. And the second, human rights protection of human rights of persons against the executive authorities, law enforcement authorities, and the judiciary has been created to observe, to monitor the actions. Then the discrimination by judiciary is not acceptable. I see one of the problems in the Supreme Court. There are many cases which the Supreme Court is returning, saying they are not significant, not important. Also, the Civil Code doesn't provide for the Supreme Court would designate itself whether its case is important or no. But the Supreme Court, using this right of last of the highest instance, recognize many cases as not important and returns them, doesn't take them into consideration. Yes, there are such cases, but in separate cases, the Supreme Court uses its right to return well justified, well reasonable like cassation complaints, just not to consider them and not to go to the subject matter of them. So the cassation court also doesn't want to take responsibility to decide on an issue on the case. Just find some pretext, some excuses that the submission was not correct, etc. Same goes about Supreme Court. The cassation court, in the opinion of cassation court, the Supreme Court is not qualified enough even for to compose to draft the cassation submission correctly. So this has to be somehow solved. This problem has to be addressed somehow. That is all from my side. Thank you for your answers. I want to add another point. I'm sorry I forgot about. Yeah, please. As I understand, these circumstances for garage became known to the foundation de jure Automaidan. I have seen some applications, some requests income from them. Taking this into account, I submitted an application. I believe that such actions by the Supreme Court about that garage are violating the authority of judiciary. So I applied to Mr. Maselko for him to address to High Council of Justice upon his own initiative for it to recognize whether such actions connected to this request do they violate, do they infringe the authority of judiciary? Oh no, I do expect a clear answer to that from him, and also the relevant answer from the Jure Foundation to my address, to my appeal. Thank you for your answers, dear colleagues, dear public. With this, the interview with the candidate for the position of the